Good morning, everyone out there on YouTube. I wanted to just get the stream started. Thank you for waiting patiently. We're running a little late on getting the stream itself started. The kids should start streaming in within the next 5 to 10 minutes. Our hope is to get started with the preliminaries at about 8 a.m. And then we will run as long as it takes, in theory, to render a verdict this morning in this case of Hughes versus Ting. Wanted to give a little heads up to folks on YouTube because once things get going, there will probably be not a lot of opportunity to check, chat, and to otherwise advise folks on what's going on. So I would like to thank in advance everyone who comes out to watch the proceedings today and hope you enjoy this as much as we probably will. We probably will. Speaking is hard at almost 8 a.m. All right, folks coming in. Grab if you do not have a writing implement, grab a pad and pen if you do not already have a pen and something to write on. Jurors on the second shelf, grab a gavel as well. You are in the jury on the second level of that cart. There are gavels. Grab one. Yes, jurors. All right. Folks on the jury, come up and get, once you've gotten a gavel, a legal pad, and a tablet, or you've got a tablet and something to write on, or your own something to write on and a pen, come up and please enter the jury box. I reiterate, jurors, go to the cart, grab a gavel from the second level, those little foam stress relief gavels. Once you have one, please report to the jury box. Attorneys for the plaintiff, please come up and sit on the right, on the bench of the right in the well. Folks, attorneys for the defendant, please sit on the left side of the well, on the bench in the well.
Hey, we gotta move, let's go. We gotta use the restroom, we're gonna do it now.
Where are you? Wait, do we stay on here?
Of course. Yes. So it's an open courtroom. It's an open courtroom. Right outside, top of, it's right outside. And there's also a restroom in the jury room.
Are you defendant? I asked that for.
It's right outside, if you need it.
I said I'm defending.
Hey, team, over here.
Jurors, have you been grabbing your gavels? Okay. Whenever you are outside of that jury box, you are to have that gavel with you so that you can be easily identified as a juror. No one is to talk with a juror outside of this courtroom. The gavels are there to identify for the whole world that you are a juror and you should not be interacted with.
I think you.
All right. Witnesses for the plaintiff who are not the plaintiff need to sit in the gallery on the right, on my right. All right, attorneys, as far as preliminaries go. You have access to power at your feet, either in the well or at council table. I believe the brick that was at the feet of plaintiff's attorneys have been moved over to accommodate jury use as well. Is that correct? All right. Also, attorneys who are up at council table, should you have a computer and you wish to use it and have it be on a 27-inch 2K ultra wide, there is an HDMI cable present to allow you to do that. There is Wi-Fi. If you require the Wi-Fi password, I'm going to do this once, and I need to, because we are being broadcast live at the moment, I'm gonna mute the courtroom audio to do that. So, is everybody ready? Who wants and needs Wi-Fi? All of the jurors present. So you have stragglers. Okay. All right.
I'm gonna go to mine first.
Right. Now then, as previously said, witnesses for each side need to sit in the gallery. They are not allowed in the well.
Let's go back to the here. While you go, and then I'll. Okay.
That being said, the plaintiff and defendant respectively are allowed to sit at counsel table for the duration of trial.
What? Oh, well, blame it a little better. Where's your main guy at, man?
All right, so plaintiff and defendant, please raise your hand. All right, you're allowed to sit at counsel table. So you can pull up a chair to counsel table.
If that corner wants. Throw them books up in this.
All right. Before we go any further, I need to address a technical issue myself, so. Everybody ready for the festivities?
Not even gonna be up there. Oh. Like I'm saying. So paintings for charity. Pretty much.
All right, we're gonna start with last minute questions or concerns before we get underway.
Are we allowed to type when?
Yes. You wouldn't be allowed to have your computers out if you weren't allowed to type. However, You have been provided with writing implements and legal pads because sometimes it's faster to do things by hand. Crazy as that may be, I know. Lest anyone wonder what the heck I'm doing, we are currently live streaming to YouTube as we speak, and you just heard the little thing of somebody joining Zoom with cameras at each council table. For some reason, this machine decided it wanted to go to sleep. So that was not good.
Me too.
All right. Now then, thank you for coming out this morning, everyone. And for, I was gonna say, for jurors, yeah, we don't have a lot of good power options for our jurors this morning. All right then, so everybody's on their respective sides. Thank you for coming out this morning to our mock trial. This is an important part of your grade, and I know you guys have been working on this for months, so best of luck to you in the presentation of your case. As I opened the floor to things for last minute questions, and having only heard the one, I'm assuming you guys are ready to blow everybody's socks off with this presentation. Okay, here's the way this is gonna work. When the case is called, we will formally begin. I will bang my gavel. When this gavel drops, this is a hot courtroom. If anybody has ever done any kind of tabletop role-playing game, Dungeons and Dragons, for example, a hot table is one where everything that you say is in character. So once this gavel drops, I'm going to treat this as if it were a real jury trial and will do my best to get everyone through this process. But that means that counsel, witnesses, and jurors, you will be in the hot seat because you will not be able to ask, well, what's my character supposed to say? Because there is no character. You will be that character. So, having said that, once again, are there any last minute questions, big or small, foundational or housekeeping, before we get started from anyone?
Your Honor, are they allowed to bring these binders up with them?
Counsel is not.
Witnesses.
No.
Okay.
The question is at counsel table, each side has two sets of physical materials of the problem set. There is also a set in the witness box. There is a separate copy in the witness box. So no, it does not need to be brought. But the witness cannot look at it without a document having been proffered by a side. So if a witness is thinking they're going to look at their witness statement and get the answer to the question, no, at least not without some more questioning by counsel. So there are separately prepared materials that are already in the witness box. That I will keep up here and will make available as necessary. Anything else? Is there any reason we cannot begin from the attorneys? From the witnesses? From the jury? From the staff present? All right.
Okay.
In that case, then, we will begin. This is the Circuit Court of Shawnee County, Kansas, calling to order case number 49 C 11410 CT 777, captioned Parker Hughes versus Ting doing business as Charity Operations Network. This is Circuit Judge Harry T. Hand presiding. We are on today in this matter for a jury trial. We have impaneled, after voir dire, a jury. I would ask that each juror please raise their hand at this time. Do you swear to discharge your duties as a juror under the state of Kansas fairly, without bias, and with all due thoroughness to the best of your ability? All right. Having been sworn, now that you've been sworn, but before the presentation of evidence, I'm going to give you the following jury instructions. These are preliminary in nature to help you through the process and understand why we are here today. You and only you will be the judges of the facts in this case. You will have to decide what happened. You should not take anything I say or do during a trial as indicating what I think of the evidence or what your verdict should be. My role is to be the judge of the law. I will make the legal decisions during this trial, and I will explain to you the legal principles that must guide you in your decisions. Neither sympathy nor prejudice should influence your verdicts. You are to apply the law as stated in the jury instructions you receive from me to the facts as you find them, and in this way decide this case. The evidence from which you are to find the facts consists of the following: the testimony of the witnesses, documents and other items received into evidence as exhibits, and any facts that are stipulated to, that is, which are formally agreed to by both parties. The following, however, are not evidence: statements, arguments, and questions of the lawyers for the parties in this case, objections by the attorneys, any testimony I tell you to disregard, and anything you may see or hear about this case outside the courtroom. You must make your decision based only on the evidence presented in this courtroom. Do not let rumors, suspicions, or anything seen or heard outside this courtroom influence your decision in any way. You should use your common sense in weighing the evidence. Consider the evidence in the light of your everyday experiences with people and events, and give it whatever weight you believe it deserves. Certain rules control what can be received into evidence. When a lawyer asks a question or offers an exhibit into evidence, and a lawyer from the other side thinks that it may not be permitted by the rules of evidence, that lawyer may object. An objection simply means that the lawyer is requesting that I make a decision on a particular rule of evidence. Objections to questions are not evidence in and of themselves. You should not be influenced by the objection or by my ruling on it. If the objection is sustained, ignore the question. If the objection is overruled, treat the answer like any other. Evidence may either be direct or circumstantial. Direct evidence is direct proof of a fact, such as testimony by a witness about what that witness personally saw, heard, or did. Circumstantial evidence is proof of one or more facts from which you could find another fact. You should consider both kinds of evidence. The law makes no distinction between the weight that is to be given to either direct or circumstantial evidence. You may decide this case solely based on circumstantial evidence. In deciding the facts, you must determine what testimony you believe and what testimony you do not believe. You are the sole judges of the credibility, the believability of the witnesses. You may believe all, some, or none of a witness's testimony. In deciding which testimony to believe, you should use the same tests of truthfulness as in your ordinary lives, including the following factors: the ability of the witness to see, hear, or know the things the witness testifies to, the quality of the witness's understanding and memory, the witness's manner and behavior while testifying, the witness's interest in the outcome of the case or any motive, bias, or prejudice, whether the witness is contradicted by anything the witness said or wrote before trial or by other evidence, and how reasonable the witness's testimony is when considered in light of other evidence that you believe. Inconsistencies or discrepancies within a witness's testimony or between the testimonies of different witnesses may or may not cause you to disbelieve a witness's testimony. Two or more persons witnessing an event may simply hear it differently. Mistaken recollection, like a person's failure to recall, is a common human experience. In weighing the effect of an inconsistency, you should also consider whether it was about a matter of importance or an insignificant detail. You should also consider whether the inconsistency was innocent or intentional. The weight of the evidence to prove a fact does not necessarily depend on the number of witnesses who testified or the quantity of evidence that was presented. More important is how believable the witnesses were and how much weight you think their testimony deserves. You will now hear the opening statements of the parties and the presentation of evidence. At the conclusion of the evidence, I will instruct you on the law to apply in this case. Is the plaintiff prepared to proceed to trial at this time? I would ask that counsel also make sure their microphones are in front of them so that they can speak directly into them. Thank you. All right. Is the defense prepared to proceed to trial at this time?
Yes, Your Honor.
All right. I will open the floor to opening statements at this time. Plaintiff, does the plaintiff have an opening statement?
Yes.
And ma'am, will you be giving that opening statement?
Yes, I will, Judge.
Would you please state your name for the record?
My name is Yasmin Alfaro.
All right, Ms. Alfaro, the floor is yours to make your opening statement.
Good morning, jurors. You might be wondering, why are we here? Well, let me paint you this picture. Imagine growing up in the small town of Eames, Kansas, and living a simple but honest life with your beautiful family. You work hard each and every day to provide for them and fulfill their needs. Well, one day in May, you decide to take the chance on the lottery and buy a ticket. And, well, you soon find out that you've won the lottery. Well, there's no need to imagine that because this is exactly what happened to my client, Mr. Parker Hughes. After my client came into possession of all this money, he knew he wanted to be smart with it. He believed that art was a good investment of his money. He was invited by the defendant, Ting, to an exclusive and prestigious fundraising gala and art auction, which was run by the Caring Hearts Children's Hospital Foundation. At this event, my client had the winning bid on an Elvita Colleen Impressionist painting. The bid was for $455,000. After the auction fees and taxes, my client paid the defendant $584,220. Upon taking possession of the painting, my client decided to get the painting insured. In order to do this, he needed to get it appraised. He contacted an expert appraiser, Cassidy Dowd, who appraised the painting and determined it to be authentic. Dowd then recommended an expert on American Impressionism and restored those paintings. And that expert was Chris Cross. Upon his examination of the painting, he determined that in his expert opinion, that the painting was a forgery. Mr. Cross reported the forgery to the FBI the same day he determined it was a forgery. The FBI is also of the opinion that the painting was a forgery. Because the painting is a forgery, my client has been harmed. Not only did my client lose $584,220, but he also lost $14,000 from the work he did on his home to showcase the forgery. He lost this money because the defendant either knew it was a forgery or should have known it was. Under our law, the defendant, as a seller of art, has the duty to exercise due diligence in determining the authenticity of his products. The defendant's failure to do so, as is required by the law, is why we are here today. Today, we are here on 4 counts. My client is going to prove to you today the following. In count 1, we are asking the court to rescind the contract on the basis of mutual mistake. We will present evidence establishing that the painting was a forgery and both my client and the defendant were mistaken as to its authenticity. In count 2, we're asking the jury to find the defendant liable for breaching his express warranties. A warranty is a promise, and an express warranty is a promise that was clearly made. We will present evidence that the defendant made express warranties to my client in which my client relied upon to his detriment, and the painting's condition did not match those warranties. In count 3, we're asking the jury to find the defendant liable for fraud. We will present evidence that A, the defendant misrepresented the painting with regard to its condition, including its authenticity. B, those representations were made knowingly that the painting was a forgery, or in the alternative, the defendant should have known it was a forgery. C, those representations were made to convince my client to purchase the painting. D, my client relied upon those representations in buying the painting. And E, my client has suffered damages of $598,220 as a result of those misrepresentations. In count 4, we are asking the jury to find the defendant liable for negligence. Through evidence, we will show that the defendant failed to exercise reasonable care or due diligence when determining the authenticity of the painting. And B, the failure to exercise reasonable care or due diligence was the primary cause of the damages suffered by my client. In summary, my client's trust was breached by the defendant, and as a result of that, my client lost over $500,000 and suffered mentally. During this trial, we're going to establish that Ting is liable for damages due to his misconduct. We are asking you, the jury, to award my client $598,220 for his economic damages. We are further asking for A, an amount for non-economic damages the jury believes appropriate to compensate my client for his mental pain, and an amount in punitive damages large enough so the defendant does not have the ability to scam another person again.
Thank you, Ms. Alfaro. Does the defense have an opening statement?
Yes, we do, Your Honor.
All right, and who will be giving that opening statement?
I will.
Please state your name for the record, sir.
Juan Piñon.
Well, Mr. Pignon, the floor is yours to make your opening statement.
Good morning, jury. We're here today to discuss the case of my client here, Ting, and the plaintiff, Parker Hughes. So during September of 2022, Parker Hughes purchased painting, Fishing at Dawn by Alvin Khalid. He bought it for $455,000, but later paid around $585,000 after taxes and different fees. The painting was checked by an expert of signatures by my client here, Ting. That expert said the signature was real. The painting also had a certificate of authenticity, which the plaintiff here, Parker Hughes did not ask for before buying it. So basically what I'm saying is that Parker Hughes did not check any authenticity. He did not ask for any data on the painting. So my client here is not liable for those charges. Thank you.
All right. We will open the floor to the plaintiff to present his case in chief. Before we go any further, I would simply admonish the jury to not laugh or giggle at the presentation of evidence by the parties. You have sworn that you will undertake your duties in a detached and unbiased manner. It may be possible to infer that there is bias if you giggle and laugh at the foibles of presentation of a statement or evidence. So, plaintiff, please call their first witness.
The plaintiff would like to call Parker Hughes to the stand, Your Honor.
Mr. Hughes, if you'd please come up to the witness box. Have a seat, sir. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you?
I do.
Right? Please make sure that you speak into the microphone. You don't need to get up and bury your face in it, but you do need to make sure you can lower your hand, sir. But you do need to make sure you're close to it, somewhat close to it, so that your voice is being picked up. All right, as the witness has been, and sir, would you please state your full name for the record?
Parker Hughes.
All right. Mr. Hughes has been sworn and his name has been placed on the record. The floor is open for direct examination by the plaintiff.
Could you state where you grew up, Mr. Hughes?
Ames, Kansas.
And where do you currently live?
Pollock, Kansas.
Do you have any other residences?
Naples, Florida.
All right. When did you win the lottery, Mr. Hughes?
May of 2022.
And how much money did you receive
500.
upon winning it?
590 million.
All right. And what did you previously do?
I worked at Gold Bars Casino,
And where's that at?
Matisse, Kansas.
All right. And how do you know the defendant?
He invited me to the art gala.
And did you purchase anything?
Yes, a painting.
And what was the name of that painting?
Fishing at dawn.
All right. How much did you pay for it?
Said what?
How much did you pay for it?
Uh, $200,000, I believe.
Do you remember when you received the painting?
October 8th of 2022.
And did you get the certificate of authenticity with that
A year after.
a year after? No further questions for now.
All right. The floor is open to defense for cross-examination.
So, Mr. Hughes, can you restate for the record, how much did you pay for the painting again?
200,000.
Are you sure about that?
Yeah.
So here on this sales receipt provided by Charity Operations Network, it states the hammer price was $455,000. You paid a $91,000 in buyer's premium and then $38,220 in Kansas taxes, which totaled out to $584,220. You bought this painting on September 7th, 2013. Could you state for the record what you said you bought, the date of the painting you bought it on?
I received it on October 8th.
On October 8th?
Yeah.
Okay. Now, were you provided a certificate of authenticity with this painting
Yes, a year after.
a year after? Here on the certificate of authenticity, it states it was dated on June 29th, 2022. So could you restate for the record what day you received the painting?
October 8th,
Of what year?
2022.
So you're telling me you said you received the certificate of authenticity a year later, yet it's still in the same year, 2022.
Yeah,
Objection, leading.
It's cross-examination. Leading
Okay.
questions are permitted. However, as there has been objection, I would remind council that asked and answered questions, there is some leeway for repetition, but not every other question.
Okay, Your Honor. Were you aware of the condition of the painting when you bought it, Mr. Hughes?
no, I was not.
Okay, no further questions, Your Honor.
All right. Does the floor is open to the plaintiff for redirect?
No, Your Honor.
All right, as the plaintiff has no redirect, the witness may step down. All right. Plaintiff, do you wish to call your next witness?
We'd like to call up Chris Cross.
All right. Ms. Cross, if you would please come up to the stand. Please have a seat. Please raise your right hand, ma'am. You swear to tell the truth, the whole truth, and nothing but the truth, so help you? All
Yes, sir.
right, you may lower your right hand. All right, and would you please state your name for the record?
Chris Cross.
All right. I would ask that new counsel for the plaintiff, please state their name for the record.
Jimena Portillo.
Right, Ms. Portillo, please make sure that you can easily talk into the microphone.
It's good.
All right, ma'am, ma'am, is it your intent to use this witness to provide expert witness testimony?
Yes.
And for what purpose is this expert witness testimony to be provided?
Can you repeat that, please?
And for what purpose is this expert witness testimony to be provided? What is Ms. Cross an expert in? What are you wanting to use her as an expert in?
Using her as an,
Ms. Portillo, you presumably do have an intent to use,
her, I'm sorry, what was that?
you stated you wish to use her as an expert. What are you hoping for her to be an expert in?
In our restoration work.
All right. All right. So then Ms. Cross, for the record, in order to expedite the proceedings, I believe it best if I qualify the expert witnesses in this case simply to ensure that their qualifications are properly known by the jury and recorded into the record, lest the jury inadvertently take under advisement expert testimony that has not been properly provided by an expert. Ms. Cross, what do you do professionally?
I'm an or
You're a what? Ma'am? Ma'am, we're just having ourselves a conversation. So ma'am, what do you do for a living?
I'm an art I'll make sure paintings are real.
Okay, so you authenticate paintings?
Yes, sir.
All right. Do you do any other kind of work involving art?
No, sir.
Nothing at all. So you are a full-time art authenticator and you don't do anything else involving art?
No.
Okay, so do you do anything else involving art?
Restore art.
Thank you, ma'am. All right, so then how long have you been restoring artwork and authenticating paintings?
About 11 years.
All right, do you have any formal training?
Yes.
Please describe that formal training. Did you go to school for art restoration?
No.
All right, did you go to any kind of technical course or correspondence training? Take a class online, anything like that?
Oh, no, sir.
Okay, so all right, then you told me you had formal training, but you didn't go to school and you have taken no other coursework. How did you become an expert in art authentication and art restoration?
It was something I started doing on my own.
And okay, so you're self-taught. How did you train yourself?
Um, Through the internet. And yeah.
All right. And you've been doing this professionally for 11 years?
Yes.
All right. Are you aware of your professional opinion of what? Do you have a professional standing in the art restoration community?
Can you repeat that again?
Are you aware of your professional standing in the art community? Are you aware of your reputation among art restorers?
Yes.
Are you considered an expert there?
Yeah.
Right. Based upon the statements of the plaintiff, I will find that she has been qualified. I will yield the floor to not the plaintiff, sorry, of the witness. I apologize. I will yield the floor to the plaintiff for direct examination of this witness with her having qualified as an expert in art restoration and authentication of artwork. Floor is yours, plaintiff. Ms. Portillo, the floor is yours.
How did you come into contact with Mr. Hughes?
He contacted me.
What work did he contact you for?
To check if the painting was real.
Which painting, ma'am?
Falling out of dawn.
Thank you, ma'am. And ma'am, did you mean fishing at dawn?
Yes, that.
Is there further direct examination of this witness?
No.
Are you certain of that? I will ask the plaintiff's counsel again, Ms. Portillo. Are you absolutely certain that there is no more direct examination of this witness?
Nothing for now.
Ma'am, that's the whole point is you are not going to get another chance to ask anything if you do not raise it on direct. And thus far, direct is considered as consisted of me qualifying a witness in anticipation of her testifying to things you have not asked. So if you believe that you are done, that's your right. I'm just making sure you genuinely are done.
Was there anything off about the painting?
Yes.
What was it? Like, what was off?
The drawing. The painting.
Can you state specifically what was off about the painting or the drawing?
Um. The brushes on the painting. The way it was painted.
Did you ever forge for greed?
No.
Where do you work at?
I'm an FBI agent.
You've ended your life of forgery, correct?
Yes.
I would ask the jury to disregard that statement as there's been no foundation laid regarding the defendant's life of forgery and not the defendant, per the witness's statements and per the witness's own statements, she's also an FBI agent. So counsel, if there is some kind of history of criminality that you want to get in, you need to lay the foundation to get it in. Would also not hurt to rehabilitate the witness's own statements because from what my own qualifying of the witness as an expert, she did not mention she was an FBI agent during that portion of her testimony either. So, plaintiff, next question.
You're an owner of an art business and not an FBI agent, correct?
Yes.
Next question, plaintiff.
How did you find out that the painting details were off? Was it a tool that was used or like what was it?
A tool,
What type of tool was it?
the brushes.
Was there a label that authenticated the painting?
No,
You are not a member of the AAA, correct?
no,
I would direct the jury to disregard that statement because there's been no foundation or even identification of what the AAA is. Would plaintiff like a 5-minute recess to get its line of questioning together?
Yes.
All right, in that case, we shall enter recess for 5 minutes. Plaintiff's team may use the jury room to coordinate. We are no longer a hot mic. We're no longer a hot courtroom because the gavel has fallen, so. So everyone else, you may use the restroom, stretch. Jurors, keep your gavels with you. Nobody talk to the jurors when they're outside of the courtroom. Keep your gavels with you and display them.
no, she didn't, she said the brush is one. Yeah, how the brush is used to. That's her thing, right? Isn't real, but it's like to see it, it's real. She didn't say this. Yeah. Okay, ahora sí dime. Just let me understand. She doesn't know.
Okay, we're looking, so what's the painting into, the painting went through the auction, no, that's a no. No, because I think that's the right one. That was a different party.
How many people are on it?
Six, like. Could you tell us who was the artist of the painting? Like the author? Just so beautiful.
You.
Can you tell us a little bit about your connection to beautiful?
So can you tell us?
Es que
si yo no te escribí
en inglés.
Can you tell us who, no, porque no, you're not gonna understand my writing. Can you tell us who is the artist on the painting?
I'm gonna be like, so when painting burns, when they're in the investigation, yeah. When painting, well, when you try to burn down,
And then she's gonna say,
during
beautiful.
investigation, and you
What they put?
Oh, beautiful.
This point in
Just not-
You,
me and my partner.
tell us?
About your connection to beautiful.
It'd be like, what do you burn?
About what?
The connection of the painting.
About what? ¿Cómo se escribe eso?
Es como así, pero.
Nomás escríbelo, I won't understand it. No sé solo, ya ves sintiendo tu letra ridículo. Es que yo lo voy a hacer más luego si lo hago.
And your connection to her.
And what?
Your connection to her.
To her, right? To her, right? You said to her?
Yes.
Okay, what else?
Yeah.
And then do I?
No, because-
Have you ever been in the original work?
After,
So, FDM.
if she brings up the art portrait, when she comes to say she's an art portrait, that's what it is. Then you like to give her create like an artist original work in order for your own. So not just say that.
Okay, what else?
Okay, so I'm gonna be like, what day did you come in town?
I only have 1, 2, 3, 4 questions.
You don't really need.
Well,
them.
So I just gotta choose 4 or another one?
And then just know like what happened.
And then like, they ask first what people feel about the decisions.
Then get it.
Well, do I only ask 4 questions or another one? So it can be 5 questions.
Yeah, the
Well, you have to wait until they get
Because-
their.
Yeah, but like, I only
Look,
like have 2 questions.
The dates, you can use this too. 'cause the
Well,
date
they might
of
use your
the
questions.
date itself
Like,
is
they might use those
on
questions.
13th.
So can I use some of the questions too?
Date is-
Yeah, if they don't use them.
Okay,
So
so
how-
because it burns.
The certificate, but they're burning stuff. The
Oh,
other.
I feel like I would be packing bro and let me.
I'm asking,
Right.
be like,
Okay,
so what?
just don't talk fast, slow it down so you can concentrate.
Burn down.
Okay,
You're good.
so I'm gonna say here.
And it'd be like the FBI investigation, but they're. Only my partner. And my
Okay, straight.
And also, I was.
I like this.
So the jury knows, it's complicated.
Yeah, the what? Your education? Oh, yeah, my education.
And where you get it from? June reason. And where did you?
Where'd you go to school?
Went to.
York, Chicago. What school specifically? Dude, they're gonna have. Because then for like, I don't know, for like, these degrees are just not credible. No?
This read the whole thing.
I was gonna be like, I have to, you can use me. I can be because of the, no, this is for something. But if they ask anything about the authenticity to you, be like, no, I did not provide that. That was provided by Gary and T, a third party authenticity group.
Passing down things that's true.
What?
That it's authentic.
Yeah, well, that's like, it's like a Cassidy doubted, so
It'd be like.
I'm hired by him.
it'll be like great granddaughter.
So why am I over here?
I'm on this side, bro.
You're defending.
That's why I'm over here.
Mabel, what's over there?
I don't get what I'm over here.
Because you're defending.
Yeah, but I should be on the plaintiff's team if you think it's true, right? Now I feel
Who's
stupid.
he's going again? What are you doing?
Morgan.
It's already all planned out. But
We were hired, she was hired by
on the
Parker
average.
Hughes. No, it goes from this to that.
And then I'm gonna go here.
Well, you're, are you defending her or are you like kind of?
I'm defending her, like asking her, Morgan's attacking.
Morgan's attacking, he's over here yelling.
Really?
I'll get it.
Let me talk to him.
Cause we're over here attacking, except for Juan. Juan will defend.
José, tú me tienes que ayudar cuando esté aquí. ¿Ok?
Yeah, you always have.
Ok, pues más vale que me ayudes.
Can't talk to George Juan.
Why?
Word, buddy. Can't talk to.
Yeah.
Morgan's attacking. Yeah, so you have to listen, so that means he, we talk with that, like, when he's over here.
Right.
And if she takes forever, you just be like, can you please answer the question? Thanks.
I'm gonna be persistent.
This is cute.
Yep.
What's it called?
You need a link or something?
Yeah.
I don't.
Got it?
Can I ask? Can I tell?
Hey, why'd you help me?
Go to conference.
Go to conference.
You
Copy
copy
and
the link.
paste.
And there's a QR code floating around Facebook.
It's also on Facebook, I guess.
On Syracuse, Syracuse Cat.
We should ask that.
All right. Jury is back where it's supposed to be. Parties are where they're supposed to be. All right, then. Is there any reason we cannot resume the mock trial? Nothing from the attorneys, nothing from the jury, nothing from the witnesses, nothing from staff? No reason? All right. This is the Circuit Court of Shawnee County once more calling to order Hughes versus Ting. We are back on the record following a short recess to allow the plaintiff to discuss presentation of their case. I would remind the witness that they are still sworn and must answer truthfully as previously sworn to. Is the plaintiff prepared to proceed, or are you done with your direct examination? Ms. Portillo.
Ready to proceed.
All right, Ms. Portillo, the floor is yours.
What other tools were used to find out the painting was fake?
Brush strokes.
How did you spot the fake?
With the UV light.
So the UV light would have been a tool that you used to detect a forgery?
Yes.
What did you find that was fake? Like with the UV lighting, like what did it find?
Differences in the painting.
Hughes asked you to do the restoration work on the painting, right?
Yes. But I didn't take it because I was booked with other projects.
I would remind the plaintiff that this is direct examination. Leading questions are not permitted. Consider this your warning. Ms. Portillo.
No further questions.
You're certain of that?
Yes.
All right. Floor is open to cross. And ma'am, please state your name for the record.
Kiergan Baker.
All right, Ms. Baker, the floor is yours for cross-examination.
Crisscross, on what day did you come in contact with Hughes?
On November 8th of 2022, if I'm not wrong.
And what did you guys discuss?
The painting,
What about the painting did you guys discuss?
he wanted to examine it to tell him if it was real or not.
Can you explain the condition of the painting?
The brush strokes on the painting, that what makes it, that what I find out, that what it was fake.
What was the condition, though?
Bad.
In Exhibit 5, it says the condition was excellent and minimal restoration. Is that correct?
The witness has not seen Exhibit 5, and Exhibit 5 has not been tendered to be admitted into evidence. So either request that she be shown a copy of it or try to get it into evidence, one or the other. What do you want, Ms. Baker?
May I take Exhibit 5 up to the stand?
I will happily provide it to the Ms. Cross, at the top left-hand corner of the page, does it say Exhibit 5? Page 1 of 3.
Yes.
It needs to be 3 of 3.
So on page 3 of the exhibit, ma'am. The floor is still yours for Cross.
So in Exhibit 5, appraisal of yours says the condition was excellent and minimal restoration. The assessment and the appraised value. So once again, can you please restate the condition of the painting?
It was in excellent condition.
Before this train of this logic goes any further, counsel, I want to make sure we're not getting into the weeds on something that could cause us an evidentiary issue in the future. Exhibit 5, the proposed Exhibit 5 is an appraisal by Cassidy Dowd, not Chris Cross. Was it your intent? I believe in the previous question, you referred to it as your appraisal to Ms. Cross. She did not do that appraisal. So if you're intending to have her review Cassidy Dowd's appraisal, that's within your right to have her do that. But I'm just trying to make sure we're not confusing the jury here because you have your own expert. So, ma'am, was that your intention in your previous question to ask her about Cassidy Dowd's appraisal, or did you mistakenly believe that this was Ms. Cross's appraisal?
No,
Which one, ma'am?
I mistakenly thought it was Chris Cross's.
Thank you. So I would direct the jury to, well, please, ma'am. So if you erroneously believed it was Chris Cross's, do you still have a question regarding that proposed exhibit?
No, sir.
All right, then, Ms. Cross, if you would please hand me that exhibit. And I would direct the jury to disregard the answer to the previous question regarding the condition of the painting as found in proposed Exhibit 5.
Chris Cross, how did the FBI find you?
Ms. Cross, do you have an answer to that question? Do you even understand what the question is referring to?
Yeah.
You do? So then what is your answer to that question?
Can you repeat that again?
How did the FBI find you?
They contacted me,
And what was the reason of contacting you?
to be an FBI informer.
Could you tell us about your past life?
What would you like to know?
Before you were hired by the FBI?
And for clarification, because this is talking about timeline, Ms. Cross, before you answer that, when did you become an FBI informant? The reason why I ask Ms. Cross is because previously, previous references to the FBI have been of a more modern vintage related to this transaction of this fishing at dawn and the alleged forgery of it. I am curious as to when that is and relative to when you first came into contact with the FBI.
Mm,
And Ms. Cross, if you don't know or don't remember, that's what you need to say.
Can you repeat that again?
When did you start working for the FBI?
And my question was, yeah, when did you in the first place start working for the FBI? As I said, Ms. Cross, if you can't recall, then that's all you need to say. But you do need to answer the question one way or the other.
No.
That was not a yes or no question.
I don't know.
Thank you, ma'am.
You mentioned you had been to jail. What did you go to jail for? Or what were you charged with?
Forgery.
Could you explain your past life of art forgery?
I do not want to put words into council's mouth, but I believe the question is, why did you do what you did when it came to forging artwork? Correct, council? That is the root of where you're trying to go with this.
Yes, Your Honor.
The only reason why I phrase it like that is to help the witness perhaps wrap their head around what your question was.
Sir.
So in either phraseology, Ms. Cross, please answer the question.
Painting.
Ma'am, that's non-responsive to the question that was asked. You were asked, Ms. Baker, I will leave the floor to you to restate your question. I apologize.
Could you explain your past life of art forgery?
Ms. Cross, do you understand the question?
Yes.
Then you should be able to answer it.
Can you repeat that again?
Could you explain your past life of art forgery?
Well, we just examine paintings.
In what way did you examine those paintings?
Ms. Cross, please answer the question. And again, if you don't understand, you need to tell council that you don't understand the question. And if you do not recall, that is your answer.
I do not recall.
Have you ever recreated the likeliness of an artist's work?
Yes.
No further questions, Your Honor.
Any redirect of this witness from the plaintiff? Ms. Portillo?
Yes.
The floor is yours for redirect.
Do you change the paintings or do you just try to restore it into its origin?
I just tried to restore them.
No further questions.
Is there any recross?
Yes, Your Honor.
All right, floor is yours for recross, Ms. Baker.
How would you go about restoring these paintings?
Can you explain that better?
I would also ask counsel sitting on benches to not gesticulate towards the witness or mouth what they believe they should be saying.
You stated that you restored paintings. How did you restore them?
I'll examine them.
With what did you examine the paintings with?
UV lights.
Asked and answered. Objection.
Sustained.
No further questions, Your Honor.
All right, the witness may step down. Right, plaintiff, do you have another witness?
Yes, we'd like to call up Harley O'Keefe.
O'Keefe, if you'd please approach. Have a seat, sir. Please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you?
Yes, Your Honor.
Please make sure you've got the microphone in a position where you can speak into it. Thank you. Please state your full name for the record.
Harley O'Keefe.
All right. New counsel for the plaintiff, please state your name for the record.
Nevaeh Hahn.
Right, and new counsel for the defendant, please state your name for the record.
Maylin Molina.
All right, Ms. Hahn, the witness is yours for direct examination.
What is your occupation?
I'm a retired FBI agent,
How long were you an FBI agent?
28 years.
Who are most likely victims of fraud?
First-time buyers.
Why do you believe it's mostly first-time buyers?
Because um, dealers and the companies take advantage of them when they buy it for the first time or when they're starting out to buy it.
Before we go any further, clarification for the record and for the jury. Dealers and sellers of what, Mr. O'Keefe?
Repeat that.
For the jury's clarification, you've been talking about questions involving sellers and you just mentioned dealers. Of what?
Of the paintings.
Of paintings. Thank you. Of art.
Yep.
Thank you. I'm sorry, Ms. Hahn, floor is yours.
Do you believe that due diligence is the primary concern for the dealer?
Yes.
How can the dealer perform due diligence?
By examining it with fluorescent lights.
Do you believe that dealers of art avoid looking into their artworks that they're selling?
Yeah.
Why is this?
Because they need to invest so the money won't be lost.
Why would the dealer not want to look into the authenticity of the painting for the best interest of the buyer?
Repeat that.
Why would the dealer of the artwork not want to look into the authenticity of a painting for the best interest of the buyer?
Not sure.
Would you like the question to be restated? Why do you believe that art sellers avoid looking into their artworks?
Because invested money would be lost.
Do you know the defendant?
I do.
How are you familiar with the defendant?
I've been suspicious of him for quite some time now.
What caused you to be suspicious of the defendant? Do you need the question to be restated?
Yeah.
Why did you find the defendant suspicious?
Because I've been studying charity operation networks.
No further questions for now, Your Honor.
There is generally no for now, counsel. It's this, so you have no further questions on direct.
No further questions, Your Honor.
All right, floor is open to cross-examination.
Wait, what did you say?
So floor is yours, ma'am.
What is your connection with Ting?
With Ting?
Yeah.
I've just been studying him.
What have you been studying with him?
Repeat that?
What have you been studying with him? With Kai Ting?
Nothing? Nothing with him.
Can you repeat that again?
Nothing.
Would council perhaps like to try a different phrasing of the question?
What have you been studying on Kai Ting?
We're studying about him.
Or looking into Kai Ting?
Forgery?
And why do you suspect forgery?
Specifically, why do you suspect him of being involved in forgery? Mr. Keefe? Please answer the question.
Nothing.
So you were studying Kai Ting for forgery because you believed he was involved in forgery, but you can't think of any reason why you were suspicious that he was committing forgery. Because that's what your testimony is.
He was committing forgery. Yes.
And the defense asked you why you believed that. And you said nothing. Would you like to take another whack at that question?
Because he was forging paintings.
What evidence do you have of him forging?
Paintings.
Can you repeat that?
Paintings.
Any specific paintings?
Yes.
And those would be?
The one he was sold.
What was the name of the painting he sold?
I do not remember it.
No further questions.
Right. Redirect from the plaintiff. Ms. Hahn, do you have any further questions on redirect for this witness?
No, Your Honor.
Sorry.
Could you please state that again, ma'am?
No, Your Honor.
All right, as there is no redirect, this witness may stand down. Is there any further evidence that the plaintiff wishes to put on or witnesses that the plaintiff wishes to call at this time?
Could you repeat that, please?
Is there any further evidence that the plaintiff wishes to put on or witnesses the plaintiff wishes to call at this time?
No, Your Honor.
All right, so the plaintiff rests and concludes its case in chief.
Yes, Your Honor.
All right, plaintiff so rests. We will recess for 5 minutes to allow everyone to stretch their legs, get a drink of water and whatnot before we come back on the record. We are now in recess. Yes, sir. Yeah, Jury, yeah, jurors, remember, take your gavels with you so that everyone can identify who you are and are part of the jury and can't talk with you about the case. Otherwise, we will get back together at, let's say, 9:30.
Who else is there? Hi, Ting, and then there's one other.
Doing all right. Want to see me get Randy ask me my nonsense. And also, defense team, I'm sorry, if you want the big screen, you just unplug the HDMI from the little computer.
Can you put on this screen the, actually, no, because we're using the HDMI. I was gonna say, can you put on the Zoom?
I mean, I can do it, but I just gotta plug it in there and I'll pop it on there.
It'll pop up, no, it'll pop up right there.
Okay.
None of the exhibits are supposed to be put on. Right, one of the stipulations, I can't hear you, that's why I didn't set up.
Oh, okay. Okay. Well, that was. I didn't really want to.
You gotta, you're gonna sit down and lay it down, that's what. Yeah, I can't do the week, we're ongoing, so I can't tell you how to. Copies will be made available to the jury at the time of the admission of the exhibit and will be made available.
Just be prepared. Just be prepared. Across the thing, that's about the question we ask. You gotta be prepared for. Don't take long to respond. You just think about it. Also, don't. If you don't know, you'll be like, I do not know the answer to that question. Line me up for, not got the answer for it. Can't talk to you.
No sé.
I wonder if my mom is watching this. Well, I was catching up on.
I used to have like a foundation.
José, bueno, pues acuérdate de mí.
You said it, not me.
Son chilenos.
You just want. I like the middle. I like the. Yeah.
All right, is everyone back?
Yes, sir.
All right.
Stay for the break.
Right then, are there any technical issues we need to address before we get back underway? Because I know there were some questions about using monitors and screens while we were on recess. Does anybody need access to this large TV for the presentation of, does the defense need access to the large TV to my left for the presentation of evidence to the jury?
Do you want to show? Yes, we do.
All right, you would please hold on one moment.
Request to put the exhibit off the screen for the moment.
The jury able to see that? All right, I'm not going to render it so that plaintiff's counsel can see, call off what exhibits you're showing. Does plaintiff's counsel have a problem with that?
I mean, we'd like to see at least a little bit.
That's good.
That'll work.
The only reason why I propose the first thing is because I have finite amounts of court. All right. Now then, jury, you can still see that sufficiently well at that angle? All right. Is there anything else we need to attend to before we get back underway in this matter?
No, Your Honor.
All
No,
right.
Your Honor.
I'm sorry, Yasmin.
I said no, Your Honor.
Thank you. All right, then. This is the Circuit Court of Shawnee County, Kansas, once more calling to order Parker Hughes versus Ting. We are back on the record in this matter for jury trial after another short recess following the conclusion of the plaintiff's case in chief. We are about to move on to the defense's case in chief, and in support of that, the defense has requested the use of courtroom electronics, specifically our 65-inch TV cart, to better display proposed exhibits to the jury. That being said, I would like to make two things clear to defense counsel before we get started. The first is that if you are going to be attempting to show documents to the jury and to the to witnesses concurrently, you will need to get that admitted into evidence before you are allowed to show it to the jury. Also, per the stipulations in this case, you may not show on the big screen any image of the painting because you have stipulated that you may show it once to allow the jury to familiarize itself with what the painting looks like. But you have stipulated that it is a 29 by 23-inch painting in your stipulations. And the purpose of that, per this court's order in the stipulations, is to prevent using digital recreations to argue about the authenticity of the painting, as the fine details of the painting are what is at issue in this case, and as was testified to by various witnesses on the plaintiff's side. So, defense counsel, do you understand the limitations you're operating under as far as using the big screen?
Yes, sir.
All right, then. I will yield the floor to you to call your first witness.
I would like to call Ting up to the stand.
Mr. Ting, if you'd please approach. Please raise your right hand, sir. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you?
I do.
All right. Please state your full legal name for the record.
Ting.
All right. And would new counsel for the defense, please enter your appearance for the record?
Juan Piñon.
And I apologize, Mr. Piñon, both you and Ms. Alfaro were at counsel table at the start of the proceedings, correct?
Yes, Your Honor.
All right, Mr. Piñon, the floor is yours.
What do you do for a living, sir?
I sell paintings for charities.
Are you the owner of your own business?
I was until I shut it down.
Do you have any indication?
Yeah, I do.
What kind of indication?
No answer to that one.
What kind of education do you have at the University of Kansas?
I finished at a graduate level for appraising art and due diligence.
Mr. Ting, before we go any further, are you intending to testify as an expert witness today?
No,
No. Counsel, are you intending to have Mr. Ting offer testimony that is in his capacity as an expert?
Yes.
So I'm going to go out on a limb and say that that testimony will relate to art.
Can you repeat that again, sir?
I'm going to go out on a limb and say that expert testimony will relate to art.
Yes, sir.
All right, so I will qualify this witness. So, how do you make your livelihood, sir?
what do you mean by that? What was
How
that?
do you earn money? How do you support yourself? You said you have your own business, or you had one. What did it do?
I would get paintings and I would sell them at charity auctions to help people and just charities in general.
And how long have you been? And so you were in the business of buying and selling paintings?
Yep.
All right. And how long have you been in the business of buying and selling paintings?
I was in business for 13 years.
You were in business?
Yeah, I shut down.
When did you shut down?
Don't quite remember that exactly. Remember the exact date.
But you were in business at the time you allegedly sold the Fishing at Dawn painting to plaintiff.
Yes, sir.
So you shut down recently then?
Yeah.
All right. So does being in the buying and selling of art require that you have some kind of professional training?
Yes, sir.
And what professional training do you have?
I have many different degrees worth of art, whether if it's authenticating it and just looking over it and making sure it's real.
All right. So did you go and you went to see, you have a professional education in art and art appraisal?
Yes, sir.
Not appraisal, authentication.
Yes, sir.
All right. Where did you go down? Do you have an undergrad degree?
Yeah.
Where did you go to undergrad?
I went to the University of Berkeley, which is in California, and I also went to the University of New York and also the University of Chicago.
So from which one did you get your undergrad degree?
The University of Berkeley.
At Cal Berkeley?
Yes, sir.
All right. And what's the most advanced degree you have?
Probably the doctorate.
All right. And what's your doctorate in?
Art. Appraisal of art, 20th century.
All right. And where did you receive that from?
The University of Chicago.
Right. What specialties do you have in the world of art authentication? What are your specialties? What areas do you possess specialized knowledge regarding art?
Personally, I feel like just checking if it's true, the signature, making sure the strokes are all correct.
That was not the question that was asked.
Repeat the question then.
In what specific art styles or periods do you have specialized knowledge?
19th century, 20th century, all that.
General purpose without regard to geography or style?
Either or.
Is that a yes? So is
Yes.
that a yes or a no?
Yeah.
Okay. All right. Are there any further questions that the defendant would like to ask of this witness regarding his professional qualifications to establish that he is an expert in art, in authentication of artwork?
No, sir.
Are there any further questions for this witness from the plaintiff regarding his professional qualifications to be an expert in this case?
What did you have your doctorate in again?
Being able to synthesize paintings and all that.
Could you give a more clear answer?
Mm. Oh, word.
You have an answer for that, Mr. Ting?
Do, but I'm trying to think the correct way. Put it the correct way, you know?
Of
Word
course,
it
sir.
correctly. Just being to authenticize the painting, look at it correctly, and make sure it's all good.
Okay, no further questions about his profession at this time.
All right. I will qualify this witness as an expert for providing expert testimony with regards to artwork. So the floor is yours, Mr. Pignon, to conduct your direct examination of this witness.
Mr. Kai Ting, when did you get the painting?
Sir, clarify which painting specifically there are.
The
I
fishing
am,
at dawn painting that you sold to Parker Hughes. When did you get it and from who?
The exact date, I can't remember the exact date, but I got it from a friend, June, a close friend, June. She donated to the charity.
so to clarify that, sir, a third party, June, donated the painting to the person who held this gala that plaintiff testified to, correct?
Yeah.
And your relationship to that plaintiff is you organized the auction?
Yeah.
So you never owned the painting, Fishing at Dawn?
Mhm.
No,
Wait, yeah, I did.
All right. All right. The floor remains yours, Mr. Pignon, for direct. I was simply attempting to clarify that and let the record reflect that he has testified that he did in fact own the Fishing at Dawn painting.
when she gifted you that painting, did she have any documentation on the painting?
Yeah, she did.
Do you know what happened to that documentation?
All that burned down in my shop
How long ago was that?
a while back. I don't remember the exact date.
Was there any investigations going on of that fire?
Yeah, fire department wanted to call it arson, but the FBI later opened up an investigation and later on closed it down because it couldn't find any information that would fall back on me. At the end of the day, why would I burn my own paintings and my own paperwork to it?
I would like to show the sales receipt on the screen.
And that is exhibit what?
Exhibit 1, Exhibit 3.
There is no foundation. Well, do you wish to show that to the, no, do you wish to show that to the witness or do you wish to show that to the jury?
The jury.
There's currently not in evidence. It has not been offered into evidence and there is no foundation for that at the moment. So if you wish to get it into evidence, you can certainly lay the foundation and move to have it admitted, but you cannot do that at the moment.
How much did you auction off the painting for?
400,000 and some change.
And what was the total price after taxes?
It was about 584,000 and some change, somewhere around there.
I would like to now show the sales receipt
To the witness or to the
admitted
jury?
to evidence.
There's still no foundation as to the sales receipt existing. Mr. Ting, upon the completion of the auction, did you deliver a document to the plaintiff accounting for the item that was sold and the amounts of money that he was to pay you? Is that a sales receipt?
Yes, sir.
You are familiar with the documents that your attorneys have filed in this matter, sir?
Yes, sir.
Is the document I'm about to hand you, is this document a true and accurate copy of the sales receipt that you delivered to the plaintiff?
Yes, sir.
I would direct counsel that I have shown him a copy of what has been labeled Exhibit 3 sales receipt, and that is also in the materials that are in front of counsel for the plaintiff. Now there is foundation to attempt to admit it.
I would like to admit Exhibit 3.
So any objection to the admission of Exhibit 3 from the plaintiff?
Objection?
No objection? So admitted. So Exhibit 3 has been admitted.
Yes, sir.
So you may, because it has been admitted into evidence, you may show it to the jury.
Yes, sir. So, Mr. Ting, at the time when you first sold the painting to Parker Hughes, did he ask for any certification of authenticity?
No, sir. He didn't really even seem too worried about any of that.
Did you provide the certification of authenticity?
Yep.
When did you do that?
I'd say. Wait, no, I didn't. I didn't skip the thing of authentication. Go back.
You did not provide the certification of authenticity?
No, sir. A third party authenticizer did.
Third party did?
Yep.
Did that third party ever provide you with a certificate of authenticity? When?
I think roughly around the same time that he delivered it to Parker Hughes.
So you received the certificate of authenticity at about the same time you delivered the painting to the plaintiff.
Yes, sir.
All right. I'm sorry for interrupting, counsel. The floor is yours.
Did Parker Hughes ever ask to preview the painting and have it examined by an expert?
No.
Did you ever examine yourself that painting?
Yes, sir.
Did you have any other third party examine it as well?
Yeah.
What did they examine it and what was their conclusion?
That it was real.
Who examined it? If you don't recall, you need to say that you do not recall.
I do not recall.
Thank you. Sorry, Mr. Pignon. I do apologize that I keep interrupting. So floor remains yours.
Did Parker Hughes ever ask to see the condition report for the E. coli painting, Fishing at Dawn?
Yeah.
No further questions, Your Honor.
All right. Ms. Alfaro, the floor is yours for cross-examination of this witness.
Mr. Ting, you said that you shut down your business shortly after selling the Fishing at Dawn painting. Why was that?
Due to how it was economically, how it just was at the moment of it.
Okay, how long did you say you were in business for again?
13 years.
Okay. Did you previously own any other auction or any other charities before the Caring Hearts charity?
No, ma'am.
All right. Didn't you state before that you had other businesses though?
Only the charity one.
So you only had one business?
Yeah, which would be getting paintings and selling them later on to help other people or just. other
That's not the
charities around.
question I'm asking, Mr. Ting. I'm asking, did you have any other businesses prior to the Caring Hearts?
Mm-mm, not that I recall.
So how again did you get the Fishing at Dawn painting?
My friend June.
What is your relation with June?
We're pretty good friends.
Okay.
What is June's full name?
Don't recall her last name.
So you're good friends with June, but you don't know their last name?
Only called her June our whole life. Never worried about her last name.
All right. Now, you said originally that when you got the painting from June, that you had the certificate of authenticity, right? But then, sorry, what was your answer to that again?
Yeah.
Okay. But then you later said that the documentation of the painting or the the certificate of authenticity of the painting burned down at your shop. Is this correct?
No, ma'am.
But you just said this earlier. Was that a lie?
No.
Just to preserve the integrity of the record, Ms. Alfaro, are you making reference to statements that the witness may have made in a sworn witness statement?
Yes.
If you make reference to that, please make specific reference to that it came, when you were talking about previously, please make sure you direct the whatever's previously from a witness statement, that it is from the witness statement and a specific line citation.
Oh, wait, I meant just now.
I understand just that because there's been a fair amount of testimony from the witness, I don't want anyone getting confused about things. When you said previously stated, and you mean the witness statement, I don't want that being conflated with what he said earlier during direct or vice versa.
All right.
I'm sorry for interrupting. Please, floor is yours.
So when you auctioned off the painting, did you have a certificate of authenticity?
Objection, repetition.
That question has been asked and answered, and the answer was that he received the certificate of authenticity at about the same time he delivered the painting. So the answer was no.
All right, I'd like to make reference to paragraph 22 in the complaint.
All right, ma'am. For the jury's edification, in paragraph 22, the exact paragraph reads as follows: the painting is a forgery. Paragraph 22 of the complaint, correct, Ms. Alfaro?
Yes.
The allegation was the painting is a forgery.
Mr. Ting, what was your answer to this complaint?
That specific allegation to paragraph 22 of the complaint.
What was the complaint? Can you repeat that? It was a
To initiate this case, the plaintiff filed a complaint. You filed an answer that contained a responsive pleading to paragraph 22. The allegation in paragraph 22 has been furnished to the jury. So do you recall what your answer to paragraph 22 was?
I don't, not exactly, not the complete answer. Not what I exactly.
Is there any objection from counsel to furnishing a copy of the answer to the witness to refresh his memory?
No objection.
Someone would please find that, as I do not have a spare copy of the answer.
I have it right here, Judge.
If you'd please furnish it to the witness.
Defendant.
No, furnish a copy, physical copy, so that he has it in front of him. Mr. Ting, what does paragraph 22 state?
Defendant is without knowledge or information sufficient to form a belief as to the truth of the allegation of paragraph 22 of the complaint.
I would also like to make reference to paragraph 23.
Paragraph 23 reads, plaintiff had no knowledge that the painting was a forgery. Ms. Alfaro, you going somewhere with this question?
What was your answer on that, Mr. Ting?
23?
Yes.
I don't remember exactly.
Would defendant please read paragraph 23 of the answer?
Defendant is without knowledge or information sufficient to form a belief as to the truth.
All right.
Of the allegations of paragraph 23 of the complaint.
Mhm.
When I ask you to read something, sir, I expect you to read it in its entirety.
Right.
Ms. Alfaro, I will note, I hope you're going somewhere with this, because while it is potentially objectionable as asked and answered, as the defendant's answers are a matter of public record, there are places you can go with this, so I will give you some leash for that, but we're getting to the point where you do need to develop something.
Okay, final one for this. Can we make reference to paragraph 45?
Paragraph 45 reads, defendant was negligent in failing to exercise due diligence in determining the authenticity, provenance, condition, and value of the painting.
And what was your response to that, Mr. Ting?
I don't remember.
Would the defendant please read the paragraph 45 of the answer?
It's not on here.
Oh. One moment while the conveyor belt delivers a copy of the requisite part of the answer.
Is it 45?
45, yes.
Defendant denies the allegation of paragraph 45 of the complaint.
All right, so now where I'm going with this is that previously in paragraph 22 and 23, you denied it, which said the painting is a forgery, which was 22, and the plaintiff had no knowledge, or sorry, for 22 specifically, the painting is a forgery. You denied that, or you said it was without knowledge or information, correct?
For paragraph 22.
Yeah.
Objection, speculation.
Counsel, you are objecting that it is speculative that a question be asked based on the pleading that you filed and you signed. Objection overruled.
All right, now for paragraph 45, you then said that it says defendant was negligent in failing to exercise due diligence in determining the authenticity, provenance, and condition. The reason I bring this up is because it is conflicting. You say you have no knowledge that the painting is a forgery, but you flat out deny in 45 that you flat out deny in paragraph 45 that you did not exercise due diligence, that you did exercise due diligence. Why are those two answers different?
Could you repeat that?
Why is your answer different for paragraph 22? You say that you have no knowledge if the painting is a forgery, but in paragraph 45, you say you deny it and say that you did do your due diligence or you did do your research and examine the painting. Why are they different?
I did do my information. I did look over it, but at the end of the day, you can never have enough information on whether to see if it's true or not. That's why I had someone else look over it after me.
So are you going against the Are you going against your claim that you had no knowledge or information about the painting whenever you said it was forgery?
Mm,
Objection, leading.
Cross-examination, leading questions are permitted. Objection overruled.
Or could you repeat that?
So are you going against your statement in paragraph 22 and then paragraph 45?
Ms. Alfaro, if I might attempt to reconcile your points in a way that the witness might better parse. Mr. Ting, in your answer, you stated that you did not have the knowledge to say one way or the other whether the painting that was sold to the plaintiff was a forgery. You've testified today that you believe it was authentic, correct?
Yep.
Ms. Alfaro is asking you, how do you reconcile those? Were you wrong then? Are you wrong now? Are you lying? Were you lying then? Are you lying now? How do you get those to fit together because they appear to Ms. Alfaro to be contradictory? Ms. Alfaro, is that a correct synthesis of your question?
Yes.
And do you understand the question she's asking, sir?
Yes, sir.
All right, please answer.
So at first I didn't really know whether to believe it or not because it was just me looking over it. That's why I had the second person look over it. And now that he approved it, that's why I believe that it's not a forgery. I believe it's a real painting.
So just to make sure that I and the jury have your testimony on this point correct. You determined that it was authentic after you came into possession of it, but before auction.
Yes, sir.
And you filed your answer claiming you didn't have enough information after you were sued, which only arose year and a half after the auction.
Yes, sir.
All right. Ms. Alfaro, any further questions on cross-examination?
All right. Going back to your previous questions asked by your counsel. You said that you did not have the certificate of authenticity until around the time you delivered it to Parker Hughes, correct?
Yes, ma'am.
All right, I would,
Please speak up, sir.
Yes, ma'am.
all right, and earlier, my client, Parker Hughes, said that he did not receive the certificate of authenticity until a year later. How do you explain this?
Well, I got my certificate of authenticity, and they told me that they were gonna deliver it to him at roughly around the same time, so I didn't know if they did or did not.
But at the auction, whenever you were selling the painting, you said that you had the certificate of authenticity, yes?
No, ma'am.
Ms. Alfaro, any further questions on cross-examination?
Yes, 1 second.
Ms. Alfaro?
No further questions.
All right. There any redirect of this witness?
No, Your Honor.
All right, this witness may stand down. All right, defense. Care to call your next witness?
I would like to call Darcy Orr to the stand.
All right, Ms. Orr, if you'd like to come on up. Please have a seat, ma'am. Please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you? You do? All right, new counsel for the defense, please enter your appearance for the record.
Mabel Zambrano.
All right, and new counsel for the plaintiff, please enter your appearance for the record.
Alexis Worsley.
All right. All right, ma'am, the floor is yours to open direct examination of this witness.
When was the painting given to you?
In 1927 is when it was given to my grandfather.
But please answer the question, ma'am.
In 1927.
No, you answered in 1927 when it came to your grandfather. When did it come to you?
After my mother passed.
Which was when?
Right before the auction when he approached me. I don't know the exact date.
All right, thank you.
When the painting went through the auction was certificate or how do you say that? Authenticity
No.
provided.
Please speak up, ma'am, so that the jury can hear you.
When the painting went through the auction was certificate or authenticity provided.
No.
Can you tell who is the artist of the painting?
Miss Colleen.
What is her first name?
Avita Bean.
Can you tell us about the Elvira, what did you say that? Colleen, and how you contact her?
I didn't personally contact her, but the painting was given to my grandfather when she drew the painting of my grandfather's house or the landscape around the house.
No, for no other questions.
Are you sure of that, about that defense? Because if you wish to end your direct examination, that's your right. I just want to make sure that you understand there are no mulligans here, barring the extraordinary.
Yeah.
All right. Is there any cross-examination of this witness?
Yes.
The floor is yours, Ms. Worsley.
All right, so you said you received the painting right before the auction. Um so it was after your mother passed,
Yes.
and you don't know exactly when that was?
No.
All right. So how was the painting, how did it get into the possession of Kai Ting?
After he had ties with my mother before she passed, so she was talking about giving it to a charity before she passed. So after that, we gave it to the charity.
So was she alive whenever she gave it?
No.
Okay. Did you ever have an appraiser take a look at the painting?
I did not, but they personally, well, when they took the painting, they did have an appraiser look at it,
They being who?
the charity.
All right.
So in line 978 and 979 of your statement says that you got your painting appraised, but you said that you didn't. You said you got a very low appraisal of 75,000,
That was the first appraisal. I got a second appraisal after that.
but you stated that you didn't get an appraisal.
Well, the first appraisal I did not take because it was a scam and they tried to take the painting for less than it was worth.
So then you had two appraisals?
Yes.
So after your mother passed, you had went to court with Kai Ting. You got a litigation matter against Kai Ting and lost.
Yes.
Why was that for?
I don't remember.
In line 1038 said you were convinced there was an influence on why she donated the painting to Kai Ting.
Yes.
Why did you think she was influenced?
Just because they were friends and they've been around each other for a long time.
Before this goes any further, I would simply remind counsel that you are not allowed to read. If a witness does not remember, you're not allowed to read a prior statement to them and get them to agree with it. Copies can be furnished to refresh memory, but generally speaking, prior statements can only be, prior sworn statements can only be used for impeachment purposes.
Did Kiting ever ask for a certificate of authenticity?
No.
Okay, so at the auction, whenever they were auctioning off the painting, you thought it was unusual that he didn't mention a certificate of authenticity?
Yes.
He being whom?
Kiting.
So your testimony is, that you were at the auction
Yes.
and you heard him make statements regarding a certificate of authenticity? Or that he did not make statements regarding a certificate of authenticity at the auction?
That he did not.
Okay. And you found that weird?
Yes.
Any further questions on cross-examination of this witness?
No further questions for now.
All right. Is there any redirect of this witness?
No, no, no.
All right. In that case, the witness may step down. All right. Vince, do you wish to call your next witness?
I'd like to call Cassidy Dowd to the stand, please, Your Honor.
Mr. Dowd, if you'd please approach. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you?
Yeah.
Yes?
Yes.
All right. Please state your full name for the record.
Cass Dowd.
All right. The witness has been sworn. New counsel for the defense, please enter your appearance.
Tatiana Esparza.
All right. And for the plaintiff?
Morgan Watson.
All right, Ms. Esparza, the floor is yours.
Okay. Cass, what do you do and how long have you been doing it for?
I am an art appraiser and I've been doing it for 50 years.
How many paintings have you appraised?
100,000.
Okay. How many of those paintings were fraud?
40%.
I'm sorry, before we go any further, you're presuming to have this witness testify in his capacity as an expert based on his half century of experience?
Yes.
Would you like me to qualify him as an expert?
Yes.
All right. So you've been doing art appraisal for 50 years?
Yes.
All right. Well, please describe your education for the court and the jury.
I have gone to 4 years of college and I have done 5 years of on-the-job training.
But you've been doing this for 50 years.
And the rest of the years just working.
So you have a bachelor's degree. Do you have any advanced degrees?
No.
Right. So tell me where you worked over the last 50 years doing what you're doing in art appraisal.
I have worked with the American Art Appraisers Association. for the last 50 years.
So you've been a member for 50 years, but did you actually work for them, or were you employed by them, or did you? or
Employed by them.
You were employed by them. All right, are you still employed by them?
Yes.
All right. Have you done any coursework whatsoever, advanced coursework to establish your professional qualifications, or is it just learning on the job?
Can you rephrase that, Kevin?
Do you have any specialty courses that have taught you how to appraise art, or have you learned primarily on the job? No?
I
Okay. So you don't have any specialty courses to the best of your knowledge, but you've done this for 50 years
Mhm.
and you're remain a member in good standing of the American Association of the Association of
Appraisers.
Appraisers. All right. Is there any further questions for this witness regarding his professional qualifications from the defense?
Not towards his expertise.
All right. Any further questions from the plaintiff with regards to this witness's professional qualifications?
No.
Based upon the witness's extensive experience, I will qualify him as an expert in art appraisal. And he may offer expert testimony within that limited scope of expertise. Defense counsel, the floor is yours to resume your direct examination. I do apologize for cutting off, but I've been trying to make sure everyone's qualified so that there are no back and forth at a later date objections about whether a witness was properly qualified.
Are you familiar with the painting in question?
Yes.
What is the name of the painting?
Fishing at dawn.
Who were you hired by to appraise this painting?
Parker Hughes.
After the appraisal, did you believe this painting was a fraud?
No.
Okay. What condition was the painting in?
It was in excellent condition.
Okay. Upon confirming the authenticity, did you write a certificate of authenticity?
No.
Okay. No further questions.
Right? Plaintiff, cross-examination, the floor is yours.
No, this one. Yeah. You claim to have a vast knowledge of fine arts, correct?
Yes.
When did you arrive at the home of Parker Hughes to appraise the painting?
November 1st of 2022.
And at what value did you appraise the painting at?
I do not remember at this time.
Did you notice any prior restoration work on the painting
Yes.
upon examination? How heavy was the restoration work?
It wasn't that heavy.
Is there further cross-examination from the plaintiff?
Yes.
Is it going to be coming anytime soon?
No further questions, Your Honor.
Are you sure?
Yes,
Positive?
100%.
All right. Any redirect?
Yes.
All right. Floor is open for redirect.
In your opinion, was the fishing at dawn painting authentic?
Yes.
No further questions.
Right? Any recross?
Yes. Okay, so in your opinion, you thought that the fishing at dawn painting was authentic, so why did you not issue a certificate of authenticity?
The appraisers are not able to give a certificate of authenticity. It should be the painter themselves.
No further questions.
All right. The witness may step down. All right. Is there any further evidence or any additional witnesses that the defense would like to call at this time?
No, Your Honor.
All right. So the defense rests. Does the defense rest?
Yes, Your Honor.
All right, we will proceed to closing arguments. Does the plaintiff have a closing argument?
Yes, Your Honor.
All right, the floor is yours to make your closing.
Your Honor, members of the jury, my name is Osvaldo Aguilar and I'm representing my client, Parker Hughes. Throughout the case, much evidence was presented in order to show how my client was wrong for trying to do something good. My client spent his money on a painting by Levita Colleen at the Caring Hearts Children's Hospital Foundation Gala. Mr. Hughes was taking the smart road by investing some of his lottery money in something other than luxuries in life. Instead, he was rewarded with a forgery of the Fishing at Dawn painting, $584,220. That is the amount that my client spent on the forgery. $584,220 plus an additional $14,000 of work done to his home to display the painting is what my client was robbed of. The plaintiff has presented evidence to charge the defendant on 4 different counts: rescission based on mutual mistake, breach of express warranties, fraud, and negligence. Based on what you have heard here today, I hope you all can unanimously come to a verdict to find the defendant guilty on these counts.
I will address this more when we get to jury instructions, but the request is to find the defendant liable, not guilty. Guilty, this is a civil proceeding, not a criminal one. Does the defense have a closing statement?
Yes, Your Honor.
The floor is the defense's to make that closing statement.
Your Honor, fellow jurors, after litigating today, I hope that you can see that Parker Hughes is responsible for his own mistake here, as he did not ask for a certificate of authenticity, did not care for the condition of the painting, and mostly bought the painting out of spite since he had just won the lottery. I hope you all can take consideration into the disputes that happened today and can all come in consensus and find my client Kai Ting not guilty of all those 4 charges. That is all I have.
Thank you. Thank you, defense, for the closing statement. Having heard closing statements, the presentation of evidence in this case has now concluded. Now, to the jury, I will direct you at this time in the law that you will apply This is fairly substantive, so I ask that you listen intently. You will also be furnished with a copy of these jury instructions as well as the jury instructions that were read at the beginning of the case for you to review in the course of your deliberations. Members of the jury, you have seen and heard all the evidence and the arguments of the lawyers. It is your duty to find the facts and to determine if the defendant is liable for damages with regard to each count of the complaint. You should consider all the evidence, the arguments, contentions, and positions urged by the attorneys, and any other contention that arises from the evidence. To find liability for a count, a majority of you must agree that defendant is liable. You do not need to be unanimous in your decision regarding liability, but you must make an independent and separate determination of liability for each count. My role now is to explain to you the legal principles that must guide you in your decisions. You must not substitute or follow your own notion of what the law is or ought to be. You must apply the law that I give you, whether you agree with it or not. The defendant, Ting, has denied the allegations of the complaint. He has likewise denied he is liable to the plaintiff for any amount of money. The fact that defendant has been sued is not evidence of his liability. The burden of proving that defendant is legally liable to plaintiff belongs to the plaintiff, not the defendant. Ting has no obligation to present any evidence at all or to prove that he is not liable to the plaintiff. The entire burden or obligation of proof is on Parker Hughes to prove that Ting was liable. This burden stays with Parker Hughes throughout the trial. In order for you to find Ting liable, the plaintiff must prove every element of every count by a preponderance of the evidence. The preponderance of the evidence is a majority of the evidence presented to which you find convincing. What constitutes a majority is within the sound discretion of the jury. The majority may be qualitative, quantitative, or both. A preponderance of the evidence is an amount of evidence which convinces you that it is more likely than not that an element of a count is true. You should use your common sense and life experience to weigh the evidence and determine whether this standard has been met. If, having heard all of the evidence, you are convinced that the plaintiff has proved each and every element of a count by a preponderance of the evidence, you should return a verdict finding defendant liable for that count. However, if you believe that one or more elements of a count has not been established by a preponderance of the evidence, then you must return a verdict finding defendant not liable for that count. In count one, the plaintiff is seeking rescission of contract based upon mutual mistake. Specifically, plaintiff seeks the rescission of the contract which was entered into with defendant to buy the Fishing at Dawn painting on the basis of mutual mistake. A party may be relieved of contractual responsibility if both parties made the same mistake concerning a basic assumption or material fact upon which the contract was based. A contract which is rescinded discharges each party from their obligations under that contract. If a party has partially or fully performed their portion of the contract, they are entitled to a return of all monies and materials expended for performance. If monies or materials cannot be returned, a party is entitled to damages from the other party in the same amount. To determine whether the contract between plaintiff and defendant should be rescinded, plaintiff must establish by a preponderance of the evidence the following two elements. One, both plaintiff and defendant were mistaken with regard to a basic assumption or material fact upon which the contract was formed. A material fact is a fact that is sufficiently important that its being different would alter the transaction. And two, both plaintiff and defendant were mistaken with regard to the same basic assumption or material fact upon which the contract was formed. This count is a mixed question of fact and law. That means that unlike the other counts of the complaint, I will determine whether the contract should be rescinded and not you, the jury. My role is to apply the law to the facts as you determine them. For this count, you will return a verdict identifying whether plaintiff has established each element of count one by a preponderance of the evidence. I will then make a determination as to the rescission of the contract based upon the facts from which your verdict has established. Count two. In count two, plaintiff seeks to have defendant found liable for damages as a result of breach of express warranties made by defendant related to the purchase of the Fishing at Dawn painting. An express warranty is a legally significant statement, promise, or representation regarding the condition of a contracted for good or service. An express warranty's significance is that if the contracted for good or service does not match the terms of the express warranty, such is a breach of contract that would entitle a party to damages. An express warranty can be established under the Uniform Commercial Code by a seller doing either of the following. 1, making any affirmation or promise to a buyer which relates to the goods to be sold and which becomes part of the basis of the bargain. This express warranty is only to the extent that the goods will match that affirmation or promise. Or 2, creating a description of any sort which relates to the goods to be sold, which is made part of the basis of the bargain. This express warranty is only to the extent that the goods will match the description. In this context, a seller is a person whose primary occupation relates to the sale of goods of the type an express warranty is being made about. A seller need not, however, use magic words such as warrant or guarantee to create an express warranty. A seller does not need to, in fact, intend to create an express warranty either if his actions would otherwise give rise to one. However, a valuation of the goods in question or a statement which is merely the seller's opinion on the goods does not create an express warranty. To determine whether defendant is liable to plaintiff for breach of express warranties, plaintiff must establish by a preponderance of the evidence the following 5 elements. 1, defendant is a seller under the Uniform Commercial Code. 2, defendant made at least one express warranty regarding the condition of the Fishing at Dawn painting. 3, the Fishing at Dawn painting did not conform to defendant's express warranties. 4, the reason why the Fishing at Dawn painting does not conform to the express warranties is because of defendant's actions or inactions. And 5, plaintiff has suffered damages as a result of the breaching of those express warranties. If you find from the evidence that all the above elements have been proven by a preponderance of the evidence, it is your duty to return a verdict finding defendant liable for breach of express warranties. If you do not find or are convinced or are unconvinced as to one or more of these things, it is your duty to return a verdict finding defendant not liable for breach of express warranties. In count 3, plaintiff seeks to have defendant found liable for damages as a result of fraud committed by defendant related to the purchase of the Fishing at Dawn painting. Fraud exists when there is a material representation of fact. The material representation of fact is made either with prior knowledge of the misrepresentation's falsity or no prior knowledge of the misrepresentation's falsity, but with recklessness regarding that lack of knowledge. 3, the misrepresentation is made with the intent to be acted upon by another. 4, the misrepresentation is relied upon by another. And 5, that reliance or action is detrimental to the person relying upon it. To determine whether determine whether defendant is liable to plaintiff for fraud, plaintiff must establish by a preponderance of the evidence the following 4 elements. Defendant misrepresented a material fact to plaintiff. 2, The misrepresentation was made knowingly or recklessly regarding its falsity. 3, the defendant intended the misrepresentation to be acted upon by plaintiff. And 4, plaintiff detrimentally relied upon that misrepresentation. If you find from the evidence that all of the above elements have been proven by a preponderance of the evidence, it is your duty to return a verdict finding defendant liable for fraud. If you do not find or are unconvinced as to one or more of these things, it is your duty to return a verdict finding defendant to not be liable for fraud. In final count, count 4, plaintiff seeks to have defendant found liable for damages as a result of negligence committed by defendant relating to the purchase of the Fishing at Dawn painting. Negligence is the failure of a party to use reasonable care to another individual whom that party owes a duty of care. Reasonable care is the care that a reasonably careful and ordinarily prudent person would use under the same or similar circumstances. I'm sorry. Reasonable care, however, does not require a person to foresee or guard against every possible situation or circumstances that are unusual or unlikely to occur. A person may fail to exercise reasonable care both through action and inaction. It is possible to not exercise reasonable care just as easily by failing to do something which a reasonably careful and ordinarily prudent person would do, as it is to do something that the same person would not. With regards to the specific facts of this case, there are several pertinent laws which you, the jury, must consider in the course of your deliberations regarding negligence. The first is that a seller of art has a fiduciary duty to exercise due diligence in the authentication of a piece of artwork. The second is that both a buyer and seller of art have the responsibility to exercise due diligence to ascertain whether a piece of art is real, not stolen, and can be legally transferred. To determine whether defendant is liable to plaintiff for negligence, plaintiff must establish by a preponderance of the evidence the following 5 elements. 1, defendant owed plaintiff a duty of care. 2, defendant breached that duty by failing to exercise reasonable care. 3, plaintiff sustained damages as a result of defendant's breach of the duty of care. 4, plaintiff's damages would not have occurred but for a defendant's breach of the duty of care. And 5, plaintiff's damages were reasonably foreseeable as a natural and probable consequence of defendant's breach of the duty of care. If you find from the evidence that all the above elements have been proven by a preponderance of the evidence, it is your duty to return a verdict finding defendant liable for negligence. If you do not find so, or are unconvinced as to one or more of these elements, it is your duty to return a verdict finding defendant to not be liable for negligence. Defendant has also asserted 3 affirmative defenses. An affirmative defense is an argument by the defendant that he should not be found liable for damages. These affirmative defenses all pertain to the actions of the plaintiff. The first affirmative defense is that of proximate cause. Defendant asserts that plaintiff is the sole proximate cause of the damages which plaintiff has allegedly suffered. A proximate cause is an act or omission which causes damages that are a natural and probable consequence of the act or omission. If you find this affirmative defense to be supported by a preponderance of the evidence, you must return a verdict finding defendant not liable for counts 2, 3, and 4, but not count 1. The second affirmative defense is that of comparative negligence. Under the doctrine of comparative negligence, a party's own fault in their suffering of injuries is used to proportionally reduce the amount of damages which may be recovered. Kansas is a pure comparative negligence state, which means that plaintiff may recover damages up to the limit which plaintiff was not at fault. For example, if plaintiff was found to be 1% at fault, 99% of the damages plaintiff sustained could be recovered. Conversely, if plaintiff by the same token, if plaintiff was found to be 99% at fault, 1% of the damages plaintiff sustained could be recovered. If you believe that a preponderance of the evidence shows that plaintiff's own negligence or fault was partially responsible for the damages plaintiff sustained, you must reduce the damages awarded to plaintiff to the degree that you find plaintiff to be at fault. The third affirmative defense is that of due diligence. Defendant asserts that plaintiff failed to do the due diligence which was required of him. As discussed earlier regarding count 4, both a buyer and seller of art have the responsibility to verify a painting is real and can be legally transferred. If you believe that a preponderance of the evidence shows that plaintiff failed to undertake the due diligence required by law, you must reduce the damages which plaintiff may recover to the degree to which plaintiff's failure contributed to the injury sustained. I would lastly like to address damages, of which I have discussed a fair bit. It is your job as the jury to not only determine if defendant is liable to plaintiff for damages, but the amount of those damages as well. If you determine that defendant is liable to plaintiff in counts 2, 3, and/or 4, you must also determine what damages, if any, to award to plaintiff. Different types of damages exist to achieve different purposes. All damages are fundamentally compensatory, intended to make an injured person whole and put them in the position they would have been but for the events which brought them to court. Economic damages are awarded to compensate for monetary and other economic losses as a result of the conduct of the other party. Non-economic damages are awarded to remedy harms which are not easily quantifiable monetarily, such as for pain and suffering which a party endures as a result of the conduct of the other party. Punitive damages are a type of damage which you may award to sanction and punish a party beyond what would normally be recovered through economic and non-economic damages. The plaintiff has requested that you award him $598,220 in economic damages. If you find defendant to be liable, you must award the plaintiff his economic damages. However, what plaintiff's economic damages are is a question of fact for you to determine. Based upon your review of the evidence, you may conclude that plaintiff's economic damages are greater or lesser than what plaintiff has requested. You are not bound to award plaintiff what plaintiff has asked for simply because plaintiff has asked for it. However, your calculation of plaintiff's economic damages, whatever they may be, must be derived only from the evidence presented. You may also, if you see fit, choose to award plaintiff for any non-economic or punitive damages which you believe are just and appropriate. The size and scope of such awards is for the jury and the jury alone to decide. However, I retain the power to, on a motion from the defendant or my own initiative, to set aside or reduce any award for non-economic damages which is contrary to the law or public policy. As with economic damages, any award of non-economic damages or punitive damages must be derived only from the evidence provided, presented today, rather. Having instructed the jury in the law, I will now wish you luck in your deliberations. You will retire to the jury room to determine your verdicts on on counts 2 through 4, as well as make the factual findings necessary for the court to determine count 1. We shall stand in recess until the jury returns. All right, jury, go into the jury room back there. I will note, just for the jury, as we are out of a hot courtroom, I will bring back shortly a binder that has all of the documents you may review. You may not review any of your case materials that are not in the binder I'm going to bring back to you in about 2 minutes. You don't know anything from that case file that was not presented to the court today or is in the binder that I give you.
I think you're thinking to that. I think it's fine. Nobody else is getting. Yeah, just so you learn something.
Team captains, I will offer you this because we did it 2 years ago. If you wish to retire to the law library to discuss settlement, now is the time to do it. You don't have to. You're confident you're going to win, but so. No, if he doesn't, they don't want to negotiate, there's not a whole lot you can do. Yeah, they're not willing. He does need to take that to his client.
Take that to your client. My client. It is your obligation.
You have a professional obligation. Attorneys, no, it doesn't matter how certain you are. As an attorney, you have to run it by your client. Just.
You need to go visit with your client. Just for general purpose. Just for general purposes,
Yeah, just go make sure he's doing okay, and also, bring up the fact that plaintiff wants to negotiate. He said, you don't have to.
For general purpose.
So you have to prepare guys to move back.
Hey, the main thing is that you're learning something.
I told you. Covered 23.5.
This on myself, I was one of the 27. And my wife and I were both listening to it.
Yeah.
You could hear it. Everybody was really clear.
Yes.
Throughout the house.
Because we actually got a microphone we should have had here.
Oh, okay. But even on a cell phone, I mean, it was really good.
Yeah.
And then they wanted to ask more. And then that's.
One minute. I just look at that. And that really. Just so you learn.
No, I put my own questions on there too.
Yeah.
Oh, I should have done it well. Okay, I had so many more bets that I missed by that much. I probably missed 7 cars by that much. No, I missed them left and right. I mean, there was one couple that I left, but they were all like crap.
Yes. You should go to law. Maybe like.
Thank you. Like action.
Or with smiling. Tell me when to suck in. I want to pull my hand and smile.
Get ready.
I feel like I'm big cheese right now. Wow.
Like all the years that were long. Wow. You know,
You think I made it up? Wait, how can you you again? No idea.
Here, one. Take your seat, buddy.
Pensa más de años.
No. No, just.
It's like you lost too. That's how it is. Wait, we can still see you. You can't see.
And the test.
All right, so who wants to talk shop?
Me.
Shop?
What?
How'd you do?
Yes, who wants to do an after action report? So how did everybody like it?
All right.
Raise your hand if you were not as prepared as you thought you were. Raise your hand if you also weren't as prepared as you thought, as you should have been after seeing it. I think every hand should be up. Almost every hand. All right, so what were the funnest deviations from the fact pattern? That crisscross was simultaneously a forger and an FBI agent is kind of up there. That Kai Ting owned a children's hospital is also pretty far up there. So come on, what do people think? It's still being decided. We are killing time until the jury decides. It can take 5 minutes. It can take 5 hours. It's not going to take them 5 hours because they're going to have to go back to school before then, but.
Longest it's been is an hour and a half. Then we had one that went 5 minutes. So anywhere between those.
5 and an hour and a half.
This is a more difficult case.
But at the same time, they don't need to be unanimous. So sitting back and listening to it, how many people had a clear idea of what the heck even happened? Yeah, exactly. It's kind of,
Yeah, 40-60%.
yeah, about 40% of the facts actually came through. I am sorry if I got to the point where I was asking, are you sure? Because
There's stuff that still needs.
there was a lot of stuff that could have been brought in and kind of,
Hunter talks about if we knew statements.
if what?
If the witnesses knew their statements, it would have been so much better.
The witnesses knew their parts? Yeah, that tends to help. Definitely tends to help. And I will be honest, that is why we've had problems in the past with witnesses not knowing their parts, but then saying, well, can I look at my script? Can I look at my witness statement? And it just destroys whatever immersion there is. And people will, and then there becomes an expectation that they'll be able to look at it, which the whole point of those prior statements is to tell people what they should know to say. And so that they can be impeached with what they said previously if they go off script. Like how the painting's valuation was testified to by the person who bought it to be 200 grand. When every piece of documentation and all the other evidence put on said paid 455. Or how Cass Dowd had a PhD in art history. So did Kai Ting, for that matter. So witnesses perhaps were not as prepared as would have been desirable, but that always happens. So, right, other thoughts? No other thoughts at all? Okay, so why was it fun? Come on.
It's fun because it's lots of our filing.
Okay, we've heard the practical and utilitarian reason of that means you're done with your final. Then again, that might not be the thing some people want. What else? I mean, attorneys. What was fun about your part of it? Definitely. Preparation does pay. Yeah, attacking also, capitalizing when you've got the witness over a barrel is also very fun. At least if it's an opposing witness. If it's your own witness, yeah, that's a bit of a more of a problem. Have you all learned something from the process, from seeing it?
Yeah.
And you've all learned that if you get summoned to jury duty, to listen to the judge? You've all learned to listen to your professors if you're going off to 2 or 4 year schools, when they say, I'm going to have an open house that will answer any question, you're going to show up next time, right?
Wait, who came? Yep, I forgot what I had to do. I don't even know.
And I spilled the beans and spoiled secrets that day. I was here for 6 hours.
Still beans?
And I was here for 6 hours doing it. I think you're taking the spilling the beans a little more literally than desired. So would you guys like to know what's up, Chris? Well, guys, how do you feel that the entire world has seen you looking not very good. That's not attorney-like behavior at all. This is a civil proceeding. No, contempt of court is the correct remedy, and I suspect the sheriff would be a little unhappy with me if I tried to dragoon people off to our county.
The deal was you gave contempt to anyone, they would have potential of return.
What's contempt?
So let the auction begin. Who wants a contempt finding against the defense? What do you give me for that contempt finding?
Define contempt, please.
Contempt is violation of a court order. Or in this case, it's detention, yes. No, I'm not going to sell contempt. As fun as that would be. As fun as that would be. And I think we took down our no electron. I believe the sign that says no electronics in the courtroom was taken down at my request. So that would be why I can't contempt you. Consider yourself lucky this time. But
No, talking about us.
talking about people at defense counsel table had their phones out and were just for the entire world to see. Yes.
So, we had, I think at max, we had like the.
98.
No, when the highest, it was like 28. But you have to think
That's
about
not the whole world.
But yeah, the teachers are going into their class, so.
Yep. So
Oh, yeah.
So- So should we talk about some of the things that I noticed that weren't brought up? Okay. What are the damages? What are the economic damages of the plaintiff? Well, he paid $455,000. Then he paid an auction fee of 91 grand and then taxes. No. Well, yeah. No. We are operating off of we are not operating off of what was testified to. We're operating off of what the problem actually said. So he's got 598-ish, so call it 600 in actual economic damages. But if you look at the pattern and you read the fact pattern, he went there intending to give money to charity. Are they actually damages if he intended to give money to charity? And he says that he bought the painting because he liked it. I mean, that it had collectible value is nice, but can't you argue that he went there to give money to charity? He gave money to charity. He likes what he received. How is that 455 grand a damage? I'm just saying that was something that could have been raised by the defense to mitigate the damages. And then you could, so that would have been something that could have been argued that was not. I mean, we had all of the craziness of Chris Cross being a convict with a heart of gold and what his credibility was. That wasn't raised at all. We had competing experts dueling about whether the use of fluorescence, which didn't get used at all. That's what I mean by fluorescence was ultraviolet. Yeah. And then the whole rationale of why that's relevant is the notion of sometimes forgers use things that are not period correct. And that's a giveaway, was a point that could have been raised and argued about. Because by all evidence in the fact pattern, pretty good forgery if it is a fake. Whether the facts are silent on whether it is actually a fake, that really is for the jury to decide because there's evidence provided on both sides. So then any arguments anybody wanted to make and didn't get a chance because they froze, locked up, thought of it too late. Yep, what is it? What do you mean time? Well, that's not how, okay. I run this courtroom, and the reason why I run a hot courtroom is because then I get to treat this like a jury trial. This is my annual jury trial practice too. Not just for you guys, it's for us here in the courthouse to make sure we don't go completely rusty on jury trials. Because normally we have an actual jury trial here once every 8 to 10 years. So it helps just keep everybody kind of in the swing about what do we kind of do during a jury trial. So, you know, during a real trial, you're not going to be allowed to lean over your shoulder and talk to your co-counsel for 5 minutes, which is kind of where we got. And you're not going to have a clock that says you have 5 minutes to ask a question. Well, because some people, it does take a little while to percolate and get the question rolling. So yeah, that's why those aren't used. So anything else? Any other thoughts, sentiments, concerns, things that we can do better in the future? Has the jury arrived at a verdict? Who wants to be the jury foreman who announces it? Okay. All right, please, and no, please get in the box. We'll get in the box. We're gonna, no, get in the box. Everybody in the box. Yeah.
We don't have no money. You better start investing on something else.
All right, is there any reason we cannot gavel back in at this time?
Yeah, the door is open.
It's fine to be open. But thank you for pointing it out. We are back on the record in Hughes versus Ting. All appearances remain the same. We had previously adjourned to allow the jury to deliberate. The jury has deliberated and has reached verdicts. Would the jury foreman please stand up? All right, Mr. Foreman, with regard to count one, with regard to the factual findings the court has asked you to make, with regard to the first finding, what are your determination of the facts with regards to the first finding, first element?
We find Kaiting's party not liable.
For count one, you were not making a liability determination on count one. So on count one, did you find that both plaintiff and defendant were mistaken with regard to a basic assumption or material fact upon which the contract was formed? And did you find that plaintiff and defendant were mistaken with regard to the same basic assumption or material fact upon which the contract was formed? All right, thank you. I will deal with count one and the legal significance of that after we've gone through the other liability and damages findings. With regard to count two, have you reached a verdict? And what is that verdict? All right. With regard to count three, fraud, have you reached a verdict? And what is that verdict? All right. And with regard to count four, negligence, have you reached a verdict? What is that verdict? All right. With regard to counts 3 and 4, the damages do not need to be assessed. When you determine damages, did you allocate each per count or did you just do a total of damages? All right. And what were your total damages for counts 3 and 4?
50% damages of the total sales price, which would be $299,110.
So half of the total economic damages asked for by defendant. So you, in your factual determinations, you found defendant to be half at fault for his damages.
All right. Did you make any further damages findings regarding non-economic and punitive damages? There are no non-economic or punitive damages. Thank you. Thank you, Mr. Foreman. You may have a seat. All right, then, as a matter of law, based upon the findings of the jury, I will find that with regard to count one, that the plaintiff has met their burden to establish that a mutual mistake exists upon which a contractual rescission may be granted. I will grant that rescission, and I will grant damages to the extent that they are in compliance with the jury award for counts 3 and 4. Therefore, I will enter an order in this case granting judgment to the defendant, to the plaintiff rather. I will grant judgment to the plaintiff in the amount of $299,110. Having reached a verdict, I will thank the jury for doing its duty and hope that you have found this process enlightening and that it has been a virtuous encounter with your civic duty. Otherwise, then, having granted judgment to the plaintiff and disposed of all counts in this matter, I will adjourn this court and end this jury trial. I'd like to thank everybody for coming out today, and I cannot help but wonder what a negotiated settlement might have looked like had it been pursued. But thank you for everyone for participating. We are now going to end the live stream because we have completed this part of it. Wave goodbye, everybody. There's a camera facing somewhere.
Shake her hand.
Wave goodbye. All right. Thank you everyone for watching. Have a wonderful day.
Oh my goodness.